going to be another week of a trial within a trial in the Senzo Meyiwa murder trial. The court has been hearing arguments regarding what evidence should be allowed. The outcome of this could determine the projection of the future case. Let's unpack what's been unfolding with reporter Manqoba Mchunu, who's been spending a lot of time in that court, very much keeping us up to speed with all the nuance and all the developments in this ongoing trial. Manqoba, thank you so much for your time. We know your workload is quite heavy, keeping people abreast of this trial that's really captured the imagination for a very, very long time. This trial within a trial, can you remind us why we're having this trial within a trial and what has unfolded in that trial within a trial over the last couple of weeks?
Well, Marcel, basically this trial within a trial is trying to establish the admissibility of two of the confessions that were made by accused 1 and 2. So that's Muzikai Ukulera Sibiya as well as Bongani Ntanzi. And in fact, these were confessions we understand were made in June of 2020, just shortly after they had been arrested. So what the court is looking at is how those confessions were extracted, how they were obtained by the police, and the keywords here is whether those confessions were made freely and voluntarily. So it's trying to determine the admissibility of those confessions and whether they were made under duress or if these accused had in fact made these confessions on their own will. So this is important because the state could then, use these confessions if at all they are made admissible or admitted as evidence before the court, and they can likely then present them to court as part of the evidence against the accused to say these two accused at some point had in fact, made these confessions and they had in fact admitted to some things as far as this. We don't know what the nature and the contents of those confessions are, but the admissions that were made in those confessions that have to do with the murder of Senzo Meyiwa. So that's going to be all highlighted if at all those confessions are inadmissible. But if the court finds that there was, violence, there was pressure, they've been tortured into making them, as the accused are claiming, then the likelihood is that those confessions are not likely then to be used in that main trial. Perhaps let's take a look at the 5 major important things when it comes to this particular trial and what this trial within a trial is all about. Really, as I've noted, it's about determining the admissibility of those confessions. Number 2, it's premised on Section 217 of the Criminal Procedure Act, which gives out or lays out how those confessions should then be obtained by the police. It should be free and voluntarily. The person that's giving that particular confession should be of sober mind, but importantly also that there should not be any undue pressure on that person to make that particular confession. But also we understand that the accused are saying that they were tortured, they were assaulted into making these confessions. So accused number 1 made 2 or rather 1 confession. So this was on the 30th of May when he was arrested. So he made a confession just hours after his arrest, but he also made a pointing out, which is also in dispute in this trial within a trial. So what a pointing out is when an accused is taken to a crime scene. So it's an extension of that confession. So after the confession, the accused will be taken to a particular area or a scene to make a pointing out based on what perhaps they have given in that confession. So accused 1 made a confession and a pointings out. Accused 2 made 2 confessions, and those 2 confessions were made, firstly, the first one just 3 days after he was arrested. This was on the 19th of June when Bongani Ntanzi had made that first confession, and the second one he had made that confession on the 24th of June before a magistrate, Vivian Cronier. So the issue here is that the defense insists these confessions were made under duress. The accused were pressured, they were assaulted by police, and they didn't really make these confessions of their own will. And the state, of course, is trying to dispute that, calling the various police officers who accompanied or escorted or arrested the accused to come and give their account of what happened. Of course, they dispute that there was any assault that had taken place at that particular moment.
Shall we hear what the judge has had to say at that point? Let's listen to that.
As we were sitting and during the break, my lord, I saw the document. When I handed it over to Mr. Baloyi, it was written confidential. However, I saw the document now roaming around in court, my lord.
Who else had that document?
I saw Muzi in possession of it, and all the accused were reading it, my lord.
Who gave them that? Do you know?
I do not know who gave it to them, my lord. And now I am being worried, my lord, for our witnesses, especially in those cases. In all these cases, my lord, there are firearms that are involved. People were shot, people were kidnapped, other people were threatened. So I was worried if my witnesses would still be alive tomorrow.
Actually, I'm shocked, that senior counsels like this can actually behave in this matter. I'm just shocked. I explicitly said it's only for the court officials. Now you're telling me the accused are having... This gentleman is right when he says he doesn't know whether tomorrow some of the witnesses will be dead or not. The nature of things, these documents are not going to form part of these proceedings because that evidence has now been contaminated. So this court makes a ruling that this information must be expunged.
So much to digest there, but tell me about this document. Why is it important?
So this is a document that was requested by the court from Vusimuzi Mohane relating to an investigation, or investigations rather, that he had done. So how we got here is because there was a question around the 17 hours that Bongani Ntanzi had been booked out. This is on the 18th of June, just prior to him making his first confession before the police. So what Vusimuzi Mohane says is that this is a time when they had gone to the mine where Bongani Ntanzi had been working to check out an alibi as to whether he was at work or not on the 26th of October in 2014. And this is the day that Senzo Meyiwa was shot and killed. So he had told investigators that on that day he was at work at a mine in Carltonville. So they'd then gone, they booked him out at 8 o'clock in the morning on the 18th, and they then proceeded to the mine where they checked out that alibi, and this alibi turned out to be false, according to what Vusimuzi Mohane said. The mine had disputed that Ntanzi was at work, and this is where Ntanzi says the assault then started. After they had finished checking that alibi at work, he says he was assaulted, firstly by the police that had accompanied him, and then they took him to Alberton where he was further assaulted. We know that we've heard evidence from Metro Police officers from Ekurhuleni who the accused say were part of that assault, and the tubing, I think a word that most of us got to hear, which means a form of suffocation where they put a plastic over the accused head, and also one of the accused saying he was electrocuted into making that particular confession, that being Bongani Ntanzi. So what you understand is that there was a question around why was he booked out the entire 17 hours up until the early hours of the 19th. This is a day that he made this first confession, and what the defense is saying is that this is the time that Ntanzi had been assaulted and tortured into making that confession. But Mohane is saying that that's not true. I actually went to do other cases. I was investigating other issues. So the court asking for him to bring proof of those cases that he had been investigating. And of course, there was a bit of contention around that 17 hours, with the defense really not, buying that issue of the 17 hours. And then, we went back to cross-examination. And of course, but I think the sticking point is still that 17 hours, the defense insisting that Ntanzi at that time had been assaulted, and this is why he had made those two confessions. But then there was a medical report that was admitted as evidence by the defense, which came back to haunt the defense when the state then led evidence on that particular medical report. It was a dentist report that showed that Ntanzi had gone to the dentist on the 22nd of June. And the investigation, or that report, also shows that Ntanzi had no oral injuries. And this was the time when he claims he was assaulted by the police. So we saw the defense now trying to retract parts of that particular medical document, asking for the court not to consider those medical, or contents that relate to his physical appearance at the time. Take a listen.
Our alibi to that effect is to say accused number 2 was consulted with the dentist. So the contents and everything contained in the docket was never been an issue to be clarified from the witness.
Yeah, so your submission is a document can be headed up holistically to this court, but this court must just peruse
May
a
I?
minuscule part of it, the 26th of June. The other information which was elicited by this gentleman, who is the state prosecutor, I must ignore that.
No, my lord, I said, let's look at the nature of the evidence.
Manqoba, what this trial within a trial has also reminded me of is to go back to 9 years ago when all of this was actually unfolding in real time. And the massive national and indeed international pressure and all of the eyes that were on the police force to be doing something, to be seen to be making headway in those days following this this murder that made all of those headlines. And the police were under a lot of pressure to make arrests as quickly as possible. So as we're hearing about the decisions and the moves and the developments that were being made by the police, you can't help but remember under what cloud all of this was taking place.
Certainly, and I think, one can imagine, what the family of Senzo Meyiwa is going through. In fact, we had a chance to speak to the mother of Senzo Meyiwa, who up until now has not found any closure. She's still, yearning for the day when, her son's killers or alleged killers are brought before or brought to book, rather, as far as this murder is concerned. So it has impacted and touched a lot of South Africans who, of course, are also hoping for some sort of finality. But I think where we are right now, Marcel, the trial within a trial, that first has to be concluded before we even get back to the main trial. So it does seem still, a long way before we get some sense of closure and finality on this matter.
So what can we expect this coming
Well,
week?
we're expecting an application, Marcel, to be heard in court, or to be argued rather. So what happened last week is that there was an application to have new evidence introduced in court. And this application was made by the state during the cross-examination of Musumuzi Mokhane. So this application has to do with the vehicle tracking system and a report that has been issued. And this is the vehicle that was driven by Surgeon Musumuzi Mokhane on that day, the 18th of June, the day that he had booked out Bongani Ntanzi for 17 hours. So he's still dwelling on this 17 hours. The defense not wanting to let go of the 17 hours because they contend this is when that assault had taken place. So what the state has done now, they've brought in a report of his vehicle to pinpoint exactly where he had traveled on that day. And we saw the defense objecting to it, saying that they had not been given time to look at this document, and they had wanted to argue against it being brought as evidence. So we're expecting those arguments to resume. They were meant to have taken place on Friday, but on Friday, the lawyer for accused 1 and 2, Thulani Mngomezulu, had called in sick. So, that delayed matters a bit. And of course, the judge was not impressed. There was also a miscommunication as to whether this particular application is still going on or not going on, because the defense had first said they are going to object to it. And then after that, a message was communicated to the state and the judge that they then changed their mind. They're not going to dispute this evidence. But then on Friday, they came back to say, okay, we've changed our mind again. Now we're going to object to it. But the judge was not impressed. Perhaps let's take a listen to how that unfolded on Friday.
There was vacillation yesterday as to whether heads should be filed. At first, I was instructed by Mr. Mngomezulu to say that there is no need. However, late around midnight, he then called me to say, upon reflection and further consultation, he is of the opinion that that matter still needs to be canvassed via heads. He's going to draft heads. He'll be available on Monday.
An advocate of this court tells me that, tell the judge it's not necessary to prepare. You know what? That application, we're no longer objecting to it. So that's how I came to this court. Okay, it's just unfortunate. There are some persons who don't take this case serious. It's obvious. at 8 o'clock. No, it's not going to go ahead. At 2:30, hey, you know what? I've changed my mind. It's going to go ahead. It looks like Rebapalafafi.
So that cross-examination continues over the next day or so.
Certainly. So Sergeant Vusumuzi Mohane continuing to be cross-examined. Where we left off, in fact, was re-examination. But because of this new evidence, we're also expecting the defense to then poke holes in that evidence. So they are going to also be given a chance to cross-examine Sergeant Vusumuzi Mohane.